Good morning, everybody. How are we all? All well? Thanks ever so much for coming to today. I know there's been lots of different activities, events this week with the Business Hive event and week. And I'm sure you've probably all booked on lots of them, so we really appreciate you taking the time to come to this event. So this is a mock tribunal, so what we're trying to do is recreate, within reason, how a tribunal would do if you unfortunately all ended up there, which we hope you don't, but sometimes these things happen. So I'm sure you'll all appreciate when you go to a tribunal for an unfair dismissal, it would be a full one-day hearing. We clearly haven't got one day. You've all got other jobs and other things that you need to do, and therefore we've consolidated it. So obviously some of the things we're having to speed up, we're having to change slightly and adapt, obviously so we can do it in this short space of time. However, the key elements of the tribunal process with the judge, the witnesses, the documents, the statements, how it kind of carries out will be the same. But I'm saying that because we'll get people saying, oh, you didn't ask this question, or Katie Davis didn't cross-examine very well, or she should have asked this. We've only got a short slot, so that's my disclaimer. It would be better on the day, okay? So we did this in, I think, May or June, and we got 100 people book on. So, and a lot of other people wanted to get on and they couldn't, hence why we did it again now, because I know some people unfortunately couldn't get booked on. Louise is nodding her head there. So we've also got the event next week in Lincoln, which is the same, which Oliver is going to be running. So if anybody can't get on, or you've got any colleagues who you think might be interested in it, there's still spaces, so you'll be able to get booked on to that as well. If you need any information about that, you don't know the dates, just let us know and we can send them to you, okay? So just to let you know, it is being recorded. However, you're not on it. It's pointing, unfortunately, at us. So you don't need to worry about, smiling or, writing notes, whatever you want. It's not at you. It's just obviously so we can share later with any other people who want to see it. So I've talked quite a lot already. My name is Katie Davis. I'm a partner in the employment department, and we've got quite a few of our colleagues here today. So unfortunately, Adam's been roped into being the dismissing officer. So Adam Otley is a partner in our commercial department and a big player in the Business Hive, working with people like Mark Webb and trying to build up relationships and obviously assist small businesses, medium businesses in the local area. So that's Adam. We've got Lily, who's a solicitor, qualified about 3 months ago into the employment department, primarily working with me and the Grimsby team. And Lily's going to be a solicitor acting for the claimants. And then we've got Holly, who doesn't normally, can I just say, look like this. I said, can you dress up a bit shabby for her role? So she said she's been getting some funny looks this morning, but normally Holly looks very smart. Holly is newly qualified in our commercial department, working with Adam and Ian Sherburn. But she's been here quite a few years now, haven't you, Holly? Because she did a different system. So. And Holly's going to be our claimant, hence why she's in the part. And then we've got Oliver Tasker, who's employment partner in charge of the employment department. And he's primarily based in Lincoln. Ollie's got the important job of being the judge today. So
I'll keep them all in order.
Yeah, he's going to tell us all off.
Yeah.
And we all want to thank Ollie because he's actually stepped in, because Teresa Thomas was meant to be being the judge, but unfortunately she's poorly. So Ollie's done us a good favour and obviously stepped in. So thank you, Oliver. Right, you should have on your seats, I've seen that a lot of you have already been reading it and skimming it, which is good. Don't worry too much about documents, because we're going to take you through them as the mock tribunal evolves. So what you'll have in there is a pack of papers, and it's got an index, and the documents are numbered, I think 1 to 35, 36, something like that. It's only a small pack. That is the documents that have been agreed between both parties before the tribunal, that both solicitors, or both, if they haven't got solicitors, the claimant and the respondent personally will agree those documents, and they'll be sent to the tribunal before. So it's meant to be an agreed bundle, but people turn up on the day with all types of bits of paper that they should have disclosed weeks ago, but that's another story. We've again limited the bundle size. We've seen document bundles that are 300 and 400 pages long, because claimants want every document under the sun in there. But we've had to limit it again because we haven't got a lot of time. But they're the documents we're going to be referring to today. So the key ones we'll refer to in evidence, and we'll get you to read them. So don't over worry about reading them now. And you've also got in that pack some witness statements, which are the witness statements which we're going to get the respondent witness, Adam, and the claimant, Holly, to read. 10 years ago, you probably would, in tribunal, get that to happen. Someone would go up and the witness would read the statement to the whole court. In order to speed things up, we don't do that nowadays. The witness statements are sent before and the judge will go away and read them. And then when the witness goes on the stand, it's presumed that everybody's read them and then questions will just be asked. But again, we're going to go back to the old-fashioned way just to allow you to be able to hear the evidence, because you haven't got time to read the statements and absorb them. And I think the witness is sitting there, reading them out loud and referring to the pages, like they used to do in the old days, 10 years ago, will actually help you, okay? So again, we've done that slightly different. So that's how we're going to run it. We're going to hand over to Oliver in a minute as the judge to take over the event and run it as it would normally be done. But I just wanted to say there are a few slight variations. Any questions so far? Thank you.
Good morning all, take a seat. So I'm Employment Judge Tasker, sitting in the Grimsby Employment Tribunal today. I see that we've got the case of a Miss Billy Boxer and Sweet of the Moment, being the claimant and respondents respectively. We'll go through the issues in terms of the case shortly. Before we do that though, on behalf of Miss Billy Boxer, the representative's name please.
Miss Elizabeth Darwood.
Thank you very much. And Miss Darwood, are you a solicitor?
I am.
Thank you very much. And on behalf of the respondent, the representative's name please.
My name is Katie Davis, I'm a solicitor, sir.
Thank you very much. And Miss Darwood, names of witnesses today please.
We've recorded one witness and that is the claimant, Miss Billy Boxer.
Miss Billy Boxer. Thank you very much. And the same for the respondent please, Mrs Davies.
Mr Henry Humbug, who is the dismissing officer, sir.
The clerks provided a copy of the bundle and also the witness statements that both parties will be relying upon. I have had a quick read through of the bundle this morning. Given the large audience that we have in the public gallery today, it's obviously of significant interest to the local area. So what we will be doing today is reading the witness statements from both, rather than ordinarily taking them as read. In terms of the case itself, I understand that both parties have agreed a list of issues that I'll have to decide today as the judge. Is that correct?
Yes, sir, that's correct.
That's correct.
Yes, sir.
Ms. Darwood, it'd be useful if you could read those aloud, please, just so that we can confirm that everything's been covered.
No problem, sir. I'll read through those now. The issues are as follows. Firstly, did the claimant resign or was she dismissed by the respondent? Secondly, if the claimant is deemed to have resigned, was this in circumstances in which they were deemed to treat themselves as having been constructively dismissed? In particular, was there a fundamental breach of contract by the respondent? If so, did the claimant resign in response to the breach? Did the claimant waive any breach and affirm the contract?
Thank you.
Thirdly, if there was a dismissal, what was the reason or principal reason for the claimant's dismissal? Was it a potentially fair reason under Section 98 of the Employment Rights Act? Did the respondent act reasonably in the circumstances, including its size and administrative resources, in treating the alleged misconduct as a sufficient reason for the claimant's dismissal? Fifth, in particular, did the respondent form a genuine belief that the claimant was guilty of misconduct alleged on reasonable grounds after such investigation as was reasonable? Was dismissal a sanction within the range of reasonable responses open to the respondent? Did the respondent follow a fair procedure? To what extent, if any, did the claimant contribute to her dismissal? And lastly, if the dismissal is found to be procedurally unfair, what is the percentage likelihood that the claimant would have been dismissed in any event?
Thank you very much. Yes, consider that covers everything. Certainly an initial issue that I'll have to determine and will be hearing evidence on our tape is regarding the alleged resignation, and then depending on my findings on that, we'll certainly be going through the usual principles in terms of the unfair dismissal tests, and then naturally depending on the findings for that, we will discuss remedy this morning as well if required. Consider that's all the list of issues and the initial issues that we need to go through, so we can crack on straight away and call our first witness. Given this is an unfair dismissal claim, it's ordinarily the respondent to provide evidence first, and I see no reason to deviate from that today. So Mr Davies, over to you. Please call your first witness.
Thank you, sir. Right, so the respondent would like to call Mr Henry Humbug, who is the dismissing officer in this case. Hello, Mr Humbug.
Morning.
Are we okay today?
Well, thank you.
Right, good. So you can see, can you check on the stand that you've got copies of all the documents?
Yep.
And your witness statements?
Yes.
Could you confirm that that is your witness statement?
It is, yes.
Okay. Could you confirm your name and address, which is on the witness statement, to the court?
Yes, my name is Henry Humbug, of 123 Sherbet Lane, Lincoln, LN1 11N.
Okay. Could I just ask, are you okay to affirm or swear an oath on the Bible?
Yes, happy to do so.
What would you like to do?
I'll swear an oath on the Bible.
There you go, you put your hand on there. Oath is done. Thank you. Right, so if you'd now like to read your statement, but where it refers to a page in the bundle, if you could stop to allow the judge and the rest of the tribunal to have the opportunity to read it. Thank you, Mr.
No problem
Humbug.
at all. I've been employed as an assistant site manager by the respondent since the 3rd of September 2014. My role involves day-to-day management and oversight of the production lines. On the 27th of June 2021, I was made aware of an incident between the claimant and another machine operator, Freddie Fighter. The shift supervisor informed me that they had witnessed the claimant punch Freddie Fighter in the face. Freddie Fighter tried to hit the claimant back and missed, but did shove her back in retaliation. The claimant was not injured. However, the punch caused Freddie Fighter a bleeding nose and she required first aid treatment. He required first aid treatment. The claimant had been sent to sit in the break room to calm down because she was continuing to act in a threatening manner towards Freddie Fighter and was also shouting at others. Indeed, I could hear the claimant shouting in the break room. Given the serious nature of the claimant's behaviour, a decision was made to send the claimant home immediately on full pay whilst the matter was investigated. The suspension was confirmed in a letter which can be found at page 24. Continue, is that enough?
Yeah, that's fine. Continue.
It was decided that Freddie Fighter would not be suspended as on initial review of the situation, it was considered that Freddie Fighter did not pose a further threat to others. The investigation process was quickly commenced, however there were unfortunately some delays with its progression due to illness and annual leave arrangements. However, I am aware that efforts were made to keep in contact with the claimant during the suspension period. It is my understanding that when telephoned by the HR team on several occasions throughout July 2021, the claimant did not answer the phone. The claimant did leave one voicemail on the 10th of July 2021. However, this was at 9:15 PM and the claimant would have been aware that the HR office is closed at this time. Brian Bias, line manager of the Rosie Apple line, was appointed as the investigatory officer. The claimant was invited to an investigation meeting which was confirmed to the claimant by a letter dated the 25th of August, which I understand is at page 26 of the bundle.
Yeah, just pause there while I have a read through. It's fine, please continue.
Thank you. To my knowledge, the claimant did not raise any issue with Brian Bias's appointment prior to the investigatory meeting. Brian Bias has worked for the respondent for 3 years on separate lines with both the claimant and Freddie Fighter, and he was deemed to be sufficiently independent and of appropriate seniority. It is my understanding that Freddie Fighter and Brian Bias were friends outside of work, but they're not that close, so this had no bearing on the investigation. As I was appointed as chair of the disciplinary process, I was not involved in the investigation, nor was I present at the investigatory meeting. However, it is clear from the minutes, which are at page 27 of the bundle.
Let's have a read through of those. Something rather brief, continue.
So it's clear from those minutes that the claimant was given the opportunity to present her evidence. Following the investigatory meeting, a report was finalised by Brian Bias. So this is at page 28 of the bundle.
Thank you. Yes, please continue.
There was no clear evidence to suggest that Freddie Fighter had thrown sweets or instigated the incident. The witness evidence available suggested that it was in fact the claimant who was violent towards Freddie Fighter, supported by Freddie Fighter's injury. However, it was acknowledged that Freddie Fighter pushed the claimant in retaliation. I am aware that the claimant has previously been spoken to about throwing sweets at those working on the rhubarb and custard line. By contrast, Freddie Fighter has never been known to cause any disruption or be responsible for any inappropriate behaviour. The claimant was invited to a disciplinary hearing to take place on the 13th of September 2021, with myself appointed as chair. The invite can be found at page 29 of the bundle.
Thank you. Please continue.
The claimant was sent an investigation report with the invite to the hearing. The claimant was sent an email before the meeting asking her to ensure she brought with her her company property, and that's at page 30 of the bundle.
Please continue.
The reason for this email was that a new keycard security pass system had been previously installed on site, and the claimant had been missed when all staff cards were collected given her suspension. As soon as the claimant arrived at the hearing, the atmosphere was tense, and the claimant began to shout about the investigation immediately. We adjourned the meeting to give the claimant the chance to read through the statements. I did go through parts of the report with her and discuss the findings due to her comments. However, I did not inform the claimant of the outcome and did not confirm that the claimant was dismissed by reason of gross misconduct. The claimant was clearly very angry, stood up and was waving her arms around, and ultimately said she was leaving and was done with this place. She threw her mobile phone and security pass and walked out of the door and off site. In my view, this was an unambiguous resignation. It was clear that the claimant intended to terminate her employment. I subsequently sent the claimant a letter by email which confirmed acceptance of her resignation given the claimant's words and action when she left the disciplinary hearing. That's at page 32 of the bundle.
Thank you. While we're there, I'm just going to read through page 31 as well, the notes from the disciplinary hearing itself. Yeah, please continue.
I confirmed in the letter that had she not resigned, she would have been dismissed for gross misconduct given the severity of her actions. Following the investigation, a disciplinary process was commenced in relation to Freddie Fighter, which resulted in a final written warning being issued to him.
Many thanks, Mr. Humberg. Ladies, I presume no supplementary questions at all, and we can continue with cross-examination.
That's correct, sir. Thank
Yes.
you.
Ms. Darwood, over to you for cross-examination.
Thanks, sir. Herbert Humboldt, I'm going to ask a number of questions now in relation to your evidence. So, starting with the incident on the 27th of June, following the incident, there were rhubarb and custard sweets as well as pear drops found on the floor of the factory, and this was more than would be expected in the ordinary course of business, wasn't it?
Yes, I understand that there was more than would be expected of both types.
So it would be a plausible explanation that the sweets were being thrown at Miss Boxer from someone working on the rhubarb and custard line.
I suppose it's a plausible explanation, but no one really knows, as no one saw any of that, as I said in my statement.
And again, following the incident, the claimant was suspended immediately. However, Miss Fighter was permitted to continue working, wasn't she?
Yes, that's right.
And at this point, there wasn't any clear evidence to suggest Miss Boxer was actually more culpable, was there?
No, I think I disagree with that. I think some of the witnesses said that Miss Boxer threw the first punch, and her actions were more aggressive after the event, and that was the reason why she was immediately suspended.
So it is the fact that Miss Fighter was actually seen to swing for Miss Boxer as well.
I believe that she was seen to push her, and I think there's differences in the evidence, but I think the key point was that Miss Boxer was continuing to be aggressive, and was a threat to others. So that was why there was the immediate suspension.
Okay. So to suspend only Miss Boxer, would it not be fair to say that this decision was a knee-jerk reaction?
I don't believe so. I believe it was because of her actions, as I said, that she was being much more aggressive and was a threat to other colleagues.
From sending Miss Boxer home, there was a significant delay in contacting her. I believe it was just under 2 months, wasn't it?
Yes, there was a delay. Unfortunately, there was annual leave at the time and sickness, which meant the HR team were particularly understaffed at the time. So yes, there was a delay, unfortunately.
Okay, and Mr. Humbug, in your witness statement, you refer to Miss Boxer calling HR out of hours. However, Miss Boxer did call the main office number quite a few times during work hours, didn't she?
I don't know. I don't man that phone, and the only time that a voicemail was left was out of hours. So we don't know if she called or not.
Okay, well, I put to you, Mr. Humbug, that more could have been done during this time to contact Miss Boxer, couldn't it?
I think we did all that we could, given the staffing issues, etc. And as I say, there were attempts made to phone Miss Boxer, but we couldn't get through to her.
Moving on to the investigation, Brian Byers was appointed as investigating officer, and I quote from paragraph 5 of your statement that he was deemed to be sufficiently independent. Is that right?
Yes, I believe he was.
And I know your role in the business as assistant line manager. As part of that, you are responsible for the day-to-day management and oversight of the production line. So, meaning you work quite closely with these people on a day-to-day basis. Is that correct?
Yes.
And so you would be aware of the relationship between Miss Fighter and Brian Byers at this point.
I was aware that there were friends as work colleagues, but wasn't aware that it would raise any issue. I didn't think they were particularly close, and I don't think others did either.
Okay, but do you acknowledge that this issue was raised by Miss Boxer during the course of the investigation?
Yes, but I think it was, but I believe it was dealt with, and the decision was taken that it wouldn't affect the decision that was made.
So you accept the issue was raised and that you were aware of the complaint, but the issue was not fully addressed and it was simply ignored, really, wasn't it?
I don't believe that was the case. I think it was assessed, and I think it was deemed that it wouldn't be an issue.
Okay. Is it correct, Mr. Humbug, that your organisation employs 367 people, with 178 of those people at the site where Miss Boxer worked?
Yes, I mean numbers change, but yeah, roughly around those.
So would it not have been reasonable that, given the size of the company, that another individual could have been appointed to investigate the disciplinary, particularly given Miss Boxer's concerns, and it wouldn't have been that difficult to find somebody else to do so?
I think, given the timing of it, as I say, in terms of staffing issues and things at the time, though there were other people, we didn't see there was an issue, so that's why we proceeded as we did.
Okay. If I could ask you to turn to page 27 of the bundle, it should be the investigation meeting notes. So at the meeting itself, Miss Boxer wasn't really given an opportunity to engage in any meaningful way, was she?
I mean, I wasn't at that meeting, but I think she was given an opportunity, and from what the mannerisms or the way that it reads, I believe that she was quite difficult herself and possibly didn't take that opportunity.
As part of the investigation, statements were taken from 2 colleagues who witnessed the incident. These were not provided to the claimant prior to the disciplinary hearing, were they?
I don't believe so, no, but we did provide them on the day.
It would be reasonable to expect that Ms Boxer would have been provided with all the evidence gathered as part of the investigation to allow her to respond and put her version of events across, didn't it?
We did adjourn the disciplinary hearing so that she had an opportunity to review those, and she didn't at any point before that hearing raise that she hadn't seen anything, and in the meeting didn't raise that she needed more time or anything like that.
If we turn to the suspension letter, which is at page 24, or the invite letter, which is at page 26, and indeed the invite to the disciplinary hearing at page 29, there's no reference to the disciplinary policy being sent to Ms Boxer at any time. So just to clarify, this wasn't sent to her, was it, at any stage during the process?
I didn't pull those letters together. I'm not in the HR team, but I assume that as it wasn't referenced, it wasn't provided. But we do have access to those policies before she left, so she would have had access to it while. And if she'd have asked for it, we'd have sent her it.
Okay, but it wasn't sent off the respondent's own back.
The letters would suggest not.
Mr Humbug, on the morning of the disciplinary hearing, the claimant was asked to return all company property that remained in her possession. I put to you that the decision to dismiss Ms Boxer had already been made and was indeed predetermined, which this email would suggest.
I think that wasn't the case. I think there's the email, the wording of the email is possibly not great. As I said, the aim was the security pass because there was a new system in place, and I think it was the aim was to get that back for the security at the site because she'd been missed because she was off because she was suspended.
In your witness statement, Mr Humbug, you accept that you read through the report and the findings with Ms Boxer during the disciplinary hearing. Was it not clear from this that the company had decided to dismiss?
No, I don't think so. I think it was we obviously gave her an opportunity to read the statements and things like that, and it seemed sensible to go through them during the process. That to me didn't necessarily mean that the decision had already been made.
You state that it was clear Ms Boxer had resigned from her role by leaving the hearing, that it was unambiguous, I believe you said. However, she did not actually say these words, did she, that she was resigning?
No, I accept she didn't say I was resigning, but she was pretty clear that she didn't want to be there, threw her arms in the air, threw things pretty much at us and said she was done with this place. So I think we interpreted it that was the end and that she was resigning and moving away. I don't think you have to actually say the words.
Okay, in light of those circumstances though, and on the basis that she didn't say that, it would be fair to say that you should have probably clarified this with her, shouldn't you?
I didn't get the opportunity. She was out the door.
Mr Humbug, the final letter sent to Ms Boxer stated that she would have been dismissed for gross misconduct in any event, and one of the reasons listed for the finding is that she had previously been warned about throwing sweets. Ms Boxer hadn't been formally disciplined for this though, had she? It had not been investigated nor disciplinary action taken?
No, I don't think there was any formal disciplinary action taken, but it seemed relevant that she was seen as a troublemaker.
So just to clarify, this was an unproven historical issue that probably should have been ignored, shouldn't it?
I don't think that necessarily. It was unproven in terms of it had gone through a formal process, but there were verbal warnings given and things. So it wasn't the core reason as to why we believed it was gross misconduct. The fight on the day and the fact that it was believed that it was her who instigated it. That was the reason why we would have dismissed for gross misconduct.
Okay, thank you, Mr Humbug. That concludes my questions.
Thank you. Mr Humbug, so you're the assistant site manager. And so would you say you're experienced in conducting disciplinary issues, given your role?
Relatively, yes. I mean, I've been involved in the process before.
So there seems to be a number of issues just from your witness evidence already. And where's your colleague? It may not be a question for you, maybe legal representative. Where's Mr. Bias today?
Unfortunately, he's in the Maldives, Mr.
Yeah.
Cheska.
Okay. Is the respondent taking this seriously?
So the respondent is taking it very seriously. However, we have the dismissing officer, so we didn't think any other evidence was required. So
Okay.
Mr. Bias, unfortunately, is not here today.
Yeah, a bit disappointing that we can't hear from Mr. Bias today, but we are where we are. And on the dismissal letter or the confirmation of resignation, Mr. Humbug, page 32, did you write that letter or was it HR?
It was written by HR, but then I had a review of it. Obviously happy with the content. I wouldn't have let it go out in my name if that was not the case.
Seems HR have been heavily involved in this throughout. We've had HR that have sent the suspension letter. Do you know who made the decision to suspend?
in the HR team?
Or which individual within your business made the decision to suspend?
I don't know.
And then HR also sent a disciplinary invite letter, and Hannah, is it Robinson? Yeah, from HR also seemed to conduct over half of the disciplinary hearing itself.
She was involved in the beginning of it. I wouldn't say she conducted it, but she was involved. Yes.
Mrs. Davis, have you got any points for your witness arising from cross-examination at all? Just purely limited to what's arisen from that?
One, sir, if you don't mind.
Yes.
In relation to the disciplinary process,
Yes.
obviously we've heard quite a lot of, evidence about the HR team being involved. Please could you confirm who ultimately made the decision to dismiss?
Myself.
Thank you. Thanks, sir.
Thank you. If nothing else, that's you done with Mr. Humberg. You can return to your seat or leave. You are released from the tribunal after giving evidence.
Thank you.
Ms. Darwood, that brings us over to the claimant's evidence.
Yes, because we're calling the claimant Miss Boxer.
Thank you very much.
Morning, Miss Boxer. Morning. Once you get your papers sorted, can you please confirm that you've got all documents and your witness statement in front of you? Yeah. So you can confirm that it is your witness statement?
Yeah.
Miss Boxer, would you mind please confirming your full name and address to the tribunal?
Yeah, so I'm Billy Boxer. I live at 11 Confrontation Street in Lincoln, LN13 6PA.
Miss Boxer, if you're happy to swear in from the Bible, please could you do so?
I suppose so.
Thank you, that's now done. Miss Boxer, if you wouldn't mind reading through your statement now, pausing where relevant if you need to refer to papers in the bundle. Thank you.
Okay. So I was employed by the respondent from the 5th of May in 2015 as a machine operator until the 13th of September 2021, when I was unfairly dismissed by the respondent. My role involved the operation of the care drop line. On the 27th of June 21, whilst working my shift, I felt something hit me. When I turned round, there was nothing to see and no one was looking my way. However, I later noticed that there was rhubarb and custard sweets littering the floor. While some sweets can fall on the floor during the normal process, it's best practice to instantly sweep all of these up. Later in the morning, I heard Freddie call me an idiot as I walked past her on my way to the toilet. When I confronted her about this and throwing sweets at me, she became very aggressive and called me a liar and tried to punish me. I defended myself and a fight broke out between myself and Freddie. The fight was broken up by my shift supervisor, Carol, and a machine operator on the Rosie Apple line, Amy Apple. Carol sent me to sit in the break room. I agreed to wait in the break room and give myself a break, as this would give everybody the chance to calm down. After 30 minutes, Carol came in and stated that I should go home, not return to work until I was contacted by the company as they were suspending me on full pay. I asked if Freddie was also being suspended, but I was told that this was none of my business. I later heard from a mutual colleague that Freddie had not been suspended. I followed Carol's instructions and I went home, and after not hearing from the respondent for several weeks, I tried to contact the main office several times. Nobody ever answered and my voicemail messages were never responded to. The respondent treated me like they had already sacked me. I was extremely worried about my future with the respondent, but was unable to look for a new job as I was hoping to return back to work as normal. On the 25th of August 21, I finally heard from the respondent via a telephone call, where I was invited to a disciplinary investigation meeting. I already felt like I'd been disciplined by the suspension and couldn't believe I was also having to attend this investigation meeting. On the same day, I received a letter inviting me to the disciplinary investigation meeting. This letter can be found at page 26.
Just have a quick look at that letter. I think we saw this earlier on. Yes. Okay, yeah, continue.
The letter stated that Freddie Fighter's best friend, Brian Bias, was going to be the investigation officer. On the 1st of September, I went to the meeting, but it was a complete waste of my time. The respondent didn't give me a chance to speak. They did ask me a few questions, but they clearly already made up their mind. I made them aware that Brian was biased as he was a friend of Freddie's, but they did nothing about it. The minutes from the meeting can be found at page 27.
Just pause there a second. Yeah, we saw those brief minutes earlier on. Continue.
Following the investigatory meeting on the 6th of September, I was invited to a disciplinary hearing which was to take place on the 13th of September. The invitation to the meeting can be found at page 29.
Continue.
The investigation report was enclosed with the invitation, but they didn't provide the statements from my colleagues, so it was impossible to understand what the one-sided report was based on. On the 13th of September, I received an email 1 hour before the hearing, demanding that I take all my company property that I had in my possession to the hearing. The email can be found at page 30.
Yeah, so let's have another look at this email. Hannah in HR again. Yeah, continue.
I felt from this and the report that a decision had already been made and they were going to dismiss me. At the hearing, I was handed the statements from my colleagues and given only 10 minutes to read through them before the meeting restarted. The chair then read out the investigation report, which described the incident by blaming everything on me, which was totally untrue. The report didn't contain any input from myself. I was also not given the chance to read the minutes of the meeting or the statements from my colleagues before the disciplinary hearing. The investigation report can be found at page 28.
Yeah, continue.
Listening to the one-sided report, there was the final straw for that meeting, as it was clear that the decision had already been made, and I walked out, leaving behind my company mobile and security pass as requested. Later that day, I received an email with the attached acceptance of my resignation letter. I was very confused as I had not resigned from my role. The letter can be found at page 32.
Yes, we've seen that one, thank you.
The letter is another example of how the decision to dismiss me was predetermined. The letter stated that if I had not resigned, I would have been dismissed in any event as my actions amounted to gross misconduct. The letter did not give me a chance to appeal. It is clear that the respondent had already made a decision to dismiss me and the process was unfair and flawed.
Many thanks. Presume no questions at the moment. Start with no, thank you. Okay. It's over to Ms Davies for cross-examination of the claimant. Thank you.
Thanks, morning, Ms Boxer. Okay, so if we can start with the incident which took place on the 27th of June. You thought Mrs Fighter from Sweets at you, didn't you?
She did.
So, right, okay. You thought she called you an idiot, didn't you?
Yeah, she did. She called me an idiot and a liar when I went off to the loo.
So, you thought she called you an idiot, you thought she was throwing sweets at you, you were angry, weren't you, Miss Boxer?
Yeah, of course I was angry. What if someone threw sweets at you, wouldn't you be angry?
That's why you punched Mrs Fighter, didn't you?
No, I won't say I punched her. She pushed me and punched me, so I defended myself.
But you were involved in a violent incident at work, that's correct, isn't it?
Well, yeah, she was violent, so I had to defend myself.
Right, if I could refer you to page 25 of the bundle. We haven't heard these in evidence yet, so please take a moment to look at these. These are the statements which were obtained from the eyewitnesses on the day of the incident at the time.
No, you mean the lies of the eyewitnesses?
Ms Boxer, would you just like to read them, please?
Whole load of lies. They're in it with you lot.
Let's just read through it, thanks, Miss Boxer.
Just want to take a minute to calm down, Ms Boxer.
Yes, continue
Oh,
with
thank you,
questioning.
Judge. So these eyewitnesses, at least two of them state that you punched Mrs. Fighter in the nose. So they're lying, are they?
Yeah, they are.
Why would they lie?
Well, it didn't happen like that. I didn't punch her. She punched me, so I defended myself. I might have caught her, but I didn't punch her.
So these people that have nothing to gain, they're lying, are they?
Yeah, they are.
Right, okay. So you made Mrs. Fighter bleed, didn't you?
Apparently.
So she was bleeding, wasn't she?
I suppose so.
And you were involved in an incident, and Mrs. Fighter then was bleeding. That's correct, isn't
Oh,
it?
yeah, but she hit me. No one asked about my injuries.
Was you bleeding?
Oh, no.
Right. You stated at paragraph 4 of your statement that after the incident where Mrs. Fighter was bleeding, after that incident, that you had to give yourself a break. That's what you say at paragraph 4 of your statement. So you had to give yourself a break. You'd lost it, hadn't you?
No, I mean, we all had a break so we could calm the situation down because she was really aggro as well.
So you needed to calm down,
We all needed to calm down.
but you needed to calm down.
I suppose so, yeah, I was mad.
Right. In your statement, you've talked about the fact you worked there for the respondent prior to the resignation for quite a period of time, since 2015. That's correct, isn't it?
Yeah, about 6 years I've been there.
Okay, so quite a period of time. Okay. And in your role, you work near machinery, is that correct?
Yeah.
So you appreciate that you need to act safely. There's machinery, is that correct, Miss Boxer?
Well, yeah, it's quite important. You've got safe practices and, you know.
So you know it's dangerous, you know it's important to be safe, but yet you allowed this violent incident to take place in this environment. That's correct.
Well, no, she started it.
But you were involved in it, is that correct?
Yeah, I was involved. Yeah.
Okay. If I refer you to page 26 of the bundle, we've already seen this today, but for the sake of the judge, it's the invite to the investigation meeting.
Thank you.
You received that, didn't you, before the investigatory meeting?
Yeah.
And in it, it clearly says that Brian Bias is going to be the investigator. That's correct, isn't it?
Yeah, it says it there.
So you knew that before the hearing?
Yeah, it says it.
And did you raise any objections about that before the hearing?
Well, no, this is the point.
So you knew that Brian Bias was going to be the investigator before the hearing, but you didn't raise any issues prior to the meeting,
No, I didn't know I had to.
even though you knew it was serious?
Yeah.
Right, okay. If you could turn to the disciplinary hearing at page 31. Again, we've already seen the minutes of this, and the judge already has read them.
Yes, thank you.
Thank you, sir. It's the minutes from the disciplinary hearing. You were given the statements, weren't you, during the disciplinary hearing?
Well, yeah, at the start. I've not seen them before then.
But we've heard in evidence today from Mr. Humbug that he gave you time to read them. Is that correct?
Well, yeah, I had about 10 minutes.
Did you ask for longer to read them, Miss Boxer?
Well, no, what's the point? They're all lies anyway.
But you didn't ask for longer?
No.
Right. So again, at the disciplinary minutes which we've looked at, it appears that you were getting angry. Is that correct?
I wouldn't say I was angry. I was getting a bit annoyed. Yes, they'd already decided they was going to sack me.
Well, the minutes say that Henry Humbug kept on getting interrupted by you. Is that correct?
I suppose so. Well, it's my chance to put my points across, wasn't it?
But you were obviously annoyed, like you've just said. You were annoyed. You were angry.
Annoyed, yeah.
So we're building up a bit of a pattern here, aren't we, Miss Boxer?
Well, no, not really.
Right. So we've had a confrontation which we accept was violent. That's correct.
Yeah, she was violent, yeah.
And you were involved in that. Is that correct?
Yeah, she punched me.
And then again, we look like we're getting angry during the disciplinary hearing. So we're building up a pattern. Have you got anger problems, Miss Boxer?
Oh, no.
Right. You walked out of the disciplinary hearing. Is that correct?
Yeah, I did.
You put your hands up in the air and you said, "I'm off. I'm done with this place." Is that correct?
Yes, but I don't know, I can't remember what I said, yeah. That sounds about right.
Can you clarify for the tribunal what the word "done" in your opinion means?
Finished.
So you were saying, "I'm finished with this place." Is that correct?
With this meeting, yeah.
So you clearly resigned, didn't you?
No, I was finished with the meeting.
Right. But you walked out and said you finished.
Finished, yeah, with the meeting, yeah.
Did you say with this meeting?
No.
Did you say with this place?
place, yeah.
Right. And then did you leave your property there when you walked out, company property, is that correct?
Well, yeah, because they asked me to bring it in, so
So you
they need it.
So you walked out of the meeting, I said, I'm done with this place, and left your property, is that correct?
Yeah.
Right. Last question, if I refer you to page 32 of the bundle, again, we've already seen this letter in evidence today, Judge, so I assume you don't need.
No, that's fine, thank you.
Thank you, sir. So in this letter from the respondent, first of all, can you confirm, did you receive this letter?
Yeah, I had it.
Right, and in it, it clearly says, I confirm acceptance of your resignation.
Yep.
Did you object to that?
Well, no, what's the point?
So you didn't raise any issues about the fact it said you'd resigned?
Well, no, I was a bit surprised that it said resigned, but what's the point? He said he was going to sack me anyway, even if I hadn't resigned, which I hadn't.
No further questions, sir.
Thank you. Miss Boxer, I'll remind you that you're under oath, so you have to tell the tribunal the truth. Just so that we are categorically clear, did you hit Freddie Fighter or not?
Yeah.
Did. Okay, thank you. Ms. Darwood, are there any points that you want to raise from cross-examination at all? No, thank you very much. So, Ms. Boxer, I've heard enough from you as well, so you are free to return next to your solicitor to conclude the evidence. Thank you very much. So there's no initial points that I want to raise, so I'm proposing that we go to our submissions, closing submissions from both parties. Respondent, please, I'd like to hear from you first in your closing submissions to the tribunal.
Thank you, sir. So the respondent submits that the claimant resigned on her own accord and that she was not constructively dismissed in accordance with section 95 1C of the Employment Rights Act 1996. The claimant resigned on the 13th of September 2021 and stated, I'm done with this place, which is confirmed in evidence today, walking out at the disciplinary hearing and leaving all her company property. Indeed, she's confirmed during cross-examination today that she considers the word done means finished. By these actions and these words, there is a clear resignation which was accepted by the respondent in writing the same day, and the claimant did not object to it, as she has confirmed in evidence today. The claimant has not set out in her claim and or raised today in evidence any examples of a fundamental breach of contract by the respondent. But in any event, the respondent submits there has been no fundamental breach which would allow her to resign in response. Any conduct by the respondent arose due to the incident on the 27th of June. Therefore, the respondent submits that if the tribunal finds that the claimant did indeed resign, then the claim must fail on the basis there's been no dismissal within the meaning of section 95 1C of the Employment Rights Act. If, which is denied, the tribunal finds that the claimant did not resign and there was a dismissal by the respondent submits that any dismissal was fair. The respondent had a fair reason in accordance with section 98 of the Employment Rights Act, being gross misconduct, due to the violent and aggressive behaviour of the claimant, who has admitted in evidence today that she hit Miss Fighter. As we've heard today, a fight took place. The fight involved two people, one being the claimant. Physical violence is classed as gross misconduct under the respondent's disciplinary policy. The evidence supports the fact that it was the claimant who punched Miss Fighter. She said in evidence today she hit her, but in any event it ended up with a bleeding nose. Furthermore, following the incident, the claimant kept on shouting and acting aggressively. The respondent submits that any reasonable person will conclude that these actions were grossly serious, particularly taking into account the environment which was dangerous in which the claimant was working. It is clear that this was the real reason for the dismissal, as the respondent immediately suspended the claimant and then a process was undertook. The respondent was entitled to dismiss on the basis that it had a reasonable belief that the claimant was involved in the physical altercation whilst at work. The claimant accepts that in her evidence, but appears to be arguing that it was Mrs. Fighter who started throwing sweets and calling her an A. The respondent submits this is insufficient mitigation and does not change the fact that the claimant was involved in a fight whilst at work. The statement which we've seen today, which were obtained, support the fact that it was the claimant who punched Mrs. Fighter, and then following the incident, the claimant continued to act in an aggressive manner. This incident was made even more serious due to the dangerous environment in which it took place, which the claimant has admitted in evidence today. Furthermore, whilst the claimant has never been formally disciplined prior to the incident, the respondent submits there had been a previous issue where the claimant had acted inappropriately and potentially aggressively. Whilst Mr. Humbug has confirmed in evidence today that he didn't take this into account in actually the decision to dismiss for gross misconduct, it again demonstrates that the claimant could not continue to trust to work in a safe manner. The claimant has failed to show at any point, including today, any remorse for her actions or a recognition of the severity of the situation. As such, it is within the range of reasonable responses for the respondent to find the claimant guilty of gross misconduct. I would refer the judge in the tribunal to the well-known case of British Home Stores and Birchall, 1978, which states that the employer must have an honest belief at the time of the dismissal that there was a fair reason to dismiss, the employer must have reasonable grounds for holding that belief, and the employer's reasonable grounds must be based on a reasonable investigation. In turning first to whether the respondent had an honest belief, which was based on reasonable grounds, we submit by the obtaining witness statements and following an investigation which confirmed that the claimant had been involved in a violent situation at work and which resulted in another colleague being hurt, the respondent has established that. There does not appear to be any dispute that a physical incident took place involving the claimant which resulted in the harm to another. The respondent disputes any inconsistency argument. Mrs. Fighter was issued with a final written warning, which is a very serious sanction. The reason Mrs. Fighter was not dismissed was because the evidence supported the fact that it was the claimant who punched her, and Mrs. Fighter was simply reacting to this. Furthermore, after the incident, the claimant continued to act aggressively, shouting at other members. Therefore, there are clear differences in the conduct of the two individuals, and the respondent was entitled to consider this in relation to its decision-making process. It is clear that the respondent could not trust the claimant to carry on working again after the incident, hence no alternative but to dismiss. In turning to the process, the respondent submits that it followed a fair and thorough investigation. The respondent suspended the claimant temporarily on full pay whilst allegations were investigated. The claimant was invited to an investigation meeting and then a disciplinary meeting and was given opportunity to put forward and make representations. The respondent provided the claimant with all appropriate invites and she was allowed to be accompanied, though she chose not to choose that right. The claimant did not ask for more time to review the statements, which she was provided with. She didn't ask for an adjournment. She was given one. She didn't ask for further time. The respondent submits that Mr. Bias was not biased as alleged, and that the claimant only mentioned this at the last minute to detract from the allegations. Furthermore, in any event, the decision to dismiss was taken by Mr. Humbug, who was acting independently and fairly. In conclusion, the respondent's primary argument is there's been no dismissal as the claimant resigned. As there's been no dismissal, the claim should fail in its entirety. In the event that the tribunal considers there has been a dismissal by the respondent submits that the decision was procedurally and substantially fair, and the claimant's claim should fail. If, which is denied, there was an unfair dismissal, the respondent submits that the claimant's conduct caused, or in the alternative, significantly contributed to her dismissal by her violent actions. The claimant was clearly involved in a violent altercation at work. She's admitted that in evidence. As such, no compensation should be awarded to reflect the claimant's contribution to this dismissal. If, which is denied, there was an unfair dismissal for procedural reasons, the respondent seeks to rely on the established case of Polkey and AE Dayton Services Limited, and submits that different procedures would have made no difference to the outcome of this case, taking into account the violence involved in this situation. Accordingly, no compensation should be awarded, or in the very least, it should be reduced by 75% to reflect the likelihood of dismissal. Thank you, sir.
Thank you. Just on the procedural points, I'm just going to remind myself of the respondent's disciplinary procedure at page 33 as well, so I don't think we specifically looked at that. So I'm just going to read through the disciplinary procedure that should have been followed.
So at page 35 it talks about the gross misconduct and physical violence as well, sir, for
Thank
sake of
you.
completeness.
Okay, thank you, Ms Davies. On to the claimant's closing submissions, please, Ms Darwood.
The claimant submits that she did not resign from her role, but was dismissed by the respondent without notice. It is submitted that this was an unfair dismissal in contravention of section 98 of the Employment Rights Act, as the respondent failed to follow the correct and proper procedure as set out in the ACAS Code of Practice. It follows that there was also no fair reason, and the decision to dismiss falls outside the band of reasonable responses open to the respondent. The claimant avers that the procedure followed by the respondent was not fair in all the circumstances. Specifically, the claimant's suspension was not only knee-jerk and unjustified, but there was a lack of contact throughout this period, which has been confirmed in evidence today. This constituted an unreasonable and punitive action by the respondent. The investigation was flawed from the outset. The investigating officer, Mr. Bias, was not sufficiently independent or impartial, and this was ignored when highlighted by the claimant. It was widely known that there was a relationship between Mr. Bias and Miss Fighter. The investigation meeting or disciplinary hearing did not provide the claimant with any meaningful opportunity to present her version of events, nor was she provided with the evidence relating to the allegations against her within a reasonable period in advance of the disciplinary hearing. In unreasonably and incorrectly assuming that the claimant had resigned, the claimant was not afforded a right of appeal. It is the claimant's submission that the outcome of the disciplinary process was eminently predetermined, and it was not considered with an open mind and in a fair and reasonable manner. Not only were there significant procedural failings, but the dismissal was also substantively unfair in that it was not in the band of reasonable responses open to the respondent. There was a lack of evidence to demonstrate that she was more culpable than Miss Fighter, and a clear and unjustified inconsistency in the treatment between them both. In relation to this, the case law tells us that when it comes to dealing with participants in the same instance, if an employer decides to dismiss someone, but not all employees involved in a fight, it needs to be able to justify the difference in treatment to counter allegations that the inconsistent treatment made the dismissal unfair. It is submitted that no clear justification has been provided in evidence by the respondent today. I refer the tribunal to the case of Westlake and ZSL Zoo, London Zoo, where it was held that no reasonable employer could have reached the decision to dismiss one employee and give the other a final written warning in circumstances where the employer acknowledged that there was no way of knowing who had started the fight, but appeared to have concluded that the claimant was more culpable because the colleague had suffered a more serious physical injury. It is submitted that in this case, the evidence similarly demonstrates no clear basis upon which to distinguish the employees to justify such inconsistent treatment between Miss Boxer and Miss Fighter or the sanction. In the instant case, there is also substantial mitigation in favour of the claimant. The alleged historical issues were never investigated, nor was any formal process commenced in relation to the same. Her record is clean over a long period of continuous service. In the case of Taylor and Parsons Peoples, the Employment Appeal Tribunal held that a reasonable employer would take account of the employee's long service and employment history, making the dismissal unfair even though the employer had a policy of always dismissing employees who deliberately struck another. There was also clear provocation in this case by Miss Fighter. In this regard, I refer the tribunal to the decision of CAPS and Baxter Down Limited, where the Employment Appeal Tribunal held that the employer was wrong to view dismissal as inevitable after the employee struck his foreman because the foreman had provoked the employee. Such provocation is clearly apparent in the instant case. The respondent failed to take these various factors into account, and to the contrary, in making the decision to dismiss the claimant, actually appears to have attached weight to historical allegations which were indeed unfounded. It follows that the claimant was unfairly dismissed by the respondent. The claimant therefore claims reinstatement, compensation and a 25% uplift to compensation due to the respondent's unreasonable failure to follow the ACAS Code of Practice. Unless I can be of any further assistance to the Tribunal, that concludes the claimant's submissions today.
Many thanks, Ms. Darwood, and thank you very much for providing copies of those cases that you're relying upon beforehand, and I'll certainly go away and consider those. As you're aware, whilst I'll read the Westlake case out of interest because it's been raised, it's only the decision of the Employment Tribunal, so I'm not bound to follow that, but I'll certainly read it with interest. Thank you both for your closing submissions. I'll now go away and deliberate my decision before returning and providing my judgment. Thank you very much. Thank you.
Right, there you go. So what we're going to do now is we're going to send the Judge Sir, Mr Tasker, away, who's going to decide what the decision will be. And while he's not here with his ears, we're going to have a little chat about what you think as well.
Yeah, you deliberate.
Yes, you don't want to persuade the judge. He'll take bribes. Right, now the judge is gone. So, obviously, like, this isn't a real tribunal, this is a case that we've developed to keep, obviously, to pull on key issues. So I'm sure you would have probably done it another way. I'm sure you appreciate that some of the things are a bit exaggerated. But it's just to give you a flavour and to see if you can pick up on the key things. So, a show of hands, who thinks it will be held to be a resignation rather than a dismissal by the respondent? So who thinks the judge will say, no, the claimant actually resigns? Anybody? Put your hands up. No, Louise is really shaking her head. Why do you think why?
I think even if we had interpreted it as a resignation, I think you would have written and said, if we have been incorrect in our assumption or you resign in haste, please contact us.
Yeah, exactly. I would normally say exactly like that, Louise. We consider that from your actions, it's deemed that it is likely to be a resignation. We're going to take it that unless we hear from you within. And I think actually Miss Boxer probably wouldn't have replied because she has a tendency of not doing that. And I think maybe you'd be protected in that way. I don't know, but that would obviously help. So anybody else? We all thinking the same kind of thing? So if we think there hasn't been a resignation, we're all proceeding then on the basis we think there's been a dismissal by the respondent. Is that correct? Okay, so going back to basics, who thinks the dismissal would be fair? 4 people, or 5 people, right. Who wants to tell me why? Is that just because you want me to win, Kevin?
I just trust Adam, It's very convincing.
I've already been proven wrong.
I just think that, obviously, there's physical evidence that there was a fight, there were good bullets, and the complaints proceed on the policy of the firm to be dismissed if you're involved in violence. So, well, possibly, yeah.
But just because you haven't dismissed the other one, doesn't mean you shouldn't dismiss this one.
No, you can treat people differently, but you've got to show there's a reason why, otherwise that's why there's an inconsistency argument, potentially, so that's why we threw Miss Fighter in there, and slightly different facts so we're talking about, is there an inconsistency or not? So we've got 4. Lawrence, so why do you think it was a fair dismissal?
Because there was a fight.
Yeah.
She was given the opportunity to put her foot forward. She didn't do so. She stormed out of the meeting, didn't engage. I just think, it was in an environment where there is machinery going on as well, and they've got a policy there. One assumes that policy is probably some staff handbook or on a notice board somewhere, so it's
on the intranet or something like that. Okay, so you two were going on the basis of it was serious, the actual reason, let's call it.
It's not often Kevin.
No,
I was going to say, you two. Kate, you said you thought it was a fair dismissal as well, is that correct?
Yeah, I think it's reasonable to dismiss, but the actual procedure is obviously correct.
1 minute, George. I like listening about
But yeah,
Can you tell?
the actual reason underneath is still
So would
of a
you?
reasonable employer.
So what would you make the final determination as then? Because you've
Should receive-
pulled
yeah.
up two things there, Kate.
Yeah.
Because you're saying the reason you think there was a potentially
Yeah.
fair reason, but then you've said I don't think the process was entirely correct.
Yeah.
I think that's
No,
it should be good. Yeah.
Yes, so that's why.
But does it come down to the size of the firm and
Well,
HR
yeah, well it does because
processes
there's two.
in
Ollie's
place?
gonna, when we've gone through all, and Oliver will explain it a bit more after the judgment. But yeah, there's two tests in an employment case: unfair dismissal. So the reason, which can be fair, unfair, and then the procedures, which can be fair or unfair. And yes, Kevin, when you're talking about procedures, which seems a bit wrong really, because procedures should just be fair. But the bigger you are, the more's expected of you. But even so, the ACAS guidance, I don't know how much you all know about the ACAS guidance, which sets down minimal requirements, has certain things that you've got to really do. And if you don't do them, then even if you've got fair reason, it can still be an unfair dismissal. But I don't want to give too much away. So the lady at the back with the blue, did you think you said it was a fair dismissal as well? Is that similar?
Yeah, I think so. I agree with what the guys are saying. Although I'm starting to waver.
Well, and the problem with the judge, an unfair dismissal, you have one judge. It's not like a discrimination case where you have a panel of three. You have one judge, and it's all this weird band of reasonable responses. So it's just one judge on the day who thinks, was it fair, was it not? I mean, normally you have a general idea if you think it's going to win or not before you go, otherwise you don't go, obviously. And we can explain if we would have taken this to court and the reasons why after. But I don't want to. You've all thought about the right things, so I'm going to get Mr. Tasker in, the judge, to read the judgment, and then we can explain a bit more. I don't want to give too much away. Is that okay? Go and get him. Yeah. We'll let you.
Sit down, thank you.
I stood up.
Yeah, sorry. Quickly. Yeah. So as you're aware, this is the case of Miss Lily Boxer against Sweet at the moment. Unemployment Judge Tasker sitting alone today as this is an ordinary unfair dismissal claim that I have been considering. You'll be pleased to hear that I have reached a decision and it is not a reserved judgment this morning. And what I propose to do is to run through my reasons, decisions and facts of the case as I find it before delivering the judgment at the end. Thank you to both witnesses for giving clear evidence today. As we know, this is a complaint by Miss Boxer that she was unfairly dismissed from her position as a machine operator from the Lincoln factory of Sweet of the Moment Limited on the 13th of September 2021. Dismissal in this case is in fact disputed by the respondent, and they put forward the assertion that the claimant resigned from her role with immediate effect during the meeting on the 13th of September. The respondent does admit that without the claimant's resignation, she would have been dismissed on the same day, and they gave the reason that Miss Boxer committed an act of gross misconduct, namely that Miss Boxer's actions of starting a physical fight with a fellow colleague fell below their expected standards of behaviour for the workplace and endangered the health and safety of others and her colleagues as well. In short, the claimant had walked over to a colleague and punched her in the face. There are 9 issues in this case that I've had to determine today. Number 1 is whether Miss Boxer did in fact resign as alleged by the respondent, or was she in fact dismissed by the respondent. Number 2, if the claimant is deemed to have resigned, was this in circumstances in which she could have deemed to treat herself as being constructively dismissed? In particular, was there a fundamental breach of her contract of employment by the respondent, and if so, did the claimant resign in response to that breach, or did the claimant waive any breach, in fact, and affirm the contract? Number 3, if there was a dismissal, what was the reason or principal reason for the claimant's dismissal, i.e. was it a fair reason under the Employment Rights Act, and namely Section 98. In this case, clearly we're considering conduct as the reason for the dismissal. Number 4, did the respondent act reasonably in the circumstances, including its size and administrative resources, in treating the alleged conduct as sufficient reason to dismiss the claimant? Number 5, did the respondent form a genuine belief that the claimant was guilty of the misconduct alleged on reasonable grounds after such investigation that was reasonable? Again, that's the case of BHS and Birchall that we've been pointed to by the respondent this morning. Number 6, was the dismissal a sanction within a range of reasonable responses open to the respondent? Number 7, did the respondent follow a fair procedure? Number 8, to what extent, if any, did the claimant contribute to her dismissal? And finally, if the dismissal was procedurally unfair, what's the percentage likelihood that the claimant would have been dismissed in any event? I've helpfully heard from Miss Boxer, who gave evidence, and from the respondent, Mr. Humberg, the assistant site manager, who was the disciplinary chair and conducted that hearing itself. Unfortunately, as we heard, Mr. Byers seemed to prefer to be on holiday in the Maldives than attend the tribunal hearing today, as it would have been extremely interesting and useful for the tribunal to hear his evidence in terms of the investigation and certainly his relationship with colleagues that the claimant has raised as an important issue. So if we turn to the law that I have applied today, the right to not to be unfairly dismissed is created by Section 94 of the Employment Rights Act, and the general provisions relating to the fairness of any such dismissal are found in Section 98. They provide that in determining whether the dismissal is fair or unfair, it's for the employer to show the reason, or if more than one, the principal reason for that dismissal. And in order to be fair, the dismissal must be one of the reasons falling within subsection 2 or some other substantial reason. As we are considering today, and there is absolutely no dispute, this is a conduct dismissal. The all-important test of reasonableness is set out in subsection 4, which states, where the employer has fulfilled the requirements of subsection 1, the determination of the question whether the dismissal is fair or unfair, having regard to the reason shown by the employer, A, depends on whether in the circumstances the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee, and B, shall be determined in accordance with equity and the substantial merits of the case. It's necessary to state that it's not Miss Boxer who is on trial this morning, far from it. It is the respondent and the reasonableness of the decision making that I have to closely examine. The Employment Tribunal receives assistance in the case of British Home Stores, as we've considered, against Birchall. This case said that all an employer needs to do in these circumstances is to satisfy the tribunal that they genuinely believe the allegation that they make against the employee, that they have reasonable grounds for that belief, and that in reaching that belief on those grounds, they've made all such inquiries as were reasonable. When the judgment in Birchall was handed down, at that time there was a burden of proof on the employer to show reasonableness, which has since been amended by legislation. The burden of proof is now neutral. It's not the task of the tribunal or myself to substitute my own view or my own judgment in terms of appropriateness of the sanction. My task today is to say whether the employer's decision fell within what we call the range of reasonable responses and the band of responses of a reasonable employer. And if I am satisfied with that, then the tests of Birchall will be passed this morning. There is recognition, as always, that there is very seldom a straightforward yes or no, black or white answer to most situations, even the one that we find before us this morning. One employer might legitimately decide to dismiss when faced with the same circumstances. Another employer may take a more lenient view. It will not avail Miss Boxer if I think that the decision to dismiss was harsh, or that I recognise other employers may have been more lenient, unless I'm also satisfied that no reasonable employer would have dismissed. So, it's important, as with any judgment, that I outline the facts of the case and what I find. It all started on the afternoon of the 27th of June 2021, when Miss Boxer and Mrs. Fighter become aware of sweets on the floor and both believe the other to be the cause. When Miss Boxer walked past Miss Fighter on the way to the toilets, Mrs. Fighter called Miss Boxer an idiot. Miss Boxer then walked up to Mrs. Fighter directly to confront her about the insult and the alleged sweet thrown from earlier in the day. During this confrontation, Miss Boxer punched Mrs. Fighter, which caused Mrs. Fighter's nose to bleed. Mrs. Fighter tried to retaliate but was hindered and instead simply pushed Miss Boxer away. Mrs. Fighter was rightly sent to receive medical treatment by the sound of her injuries, and the claimant was sent to the break room and, as we've heard, to calm down. She was then verbally suspended from work on full pay at that point. The claimant was suspended from that date until her dismissal on the 13th of September. The investigation process had been commenced quickly with fellow employees, as we've seen from the statements this morning. However, the first successful contact between the parties took place on the 25th of August, allegedly, as we've heard from Mr. Humbert this morning, due to illness and annual leave over the summer months, particularly from the HR team. The investigation meeting finally took place on the 1st of September. The respondent deemed Mr. Brian Byers to be the most appropriate person to carry out the investigation. As a line manager allocated to a separate line, he was deemed by the respondent to be sufficiently senior and also independent. However, the objectiveness of Mr. Byers was questioned at that meeting, albeit not until the end of that meeting, and that was as a consequence of the alleged friendship between Mr. Byers and Mrs. Fighter. Today we've heard from the respondent that Mr. Byers is friends with Mrs. Fighter, and with hindsight, somebody more suitable should have been appointed, particularly given the size of the respondent and the resources available to them. The notes from the meeting that we've been through this morning, the statements from all the witnesses and parties, and the investigation report were helpfully included within the bundle. It was decided that Mr. Humbert, the assistant site manager of the factory, was the most appropriate person to hear the disciplinary. Miss Robson, HR manager, was also present in her capacity of note taker, and we've also seen from the numerous letters that she was involved to a great degree, I would find. At the start of the disciplinary meeting, Miss Boxer was given the opportunity to read the statements from her colleagues. These documents had in fact been missing from the investigation report and had not been provided as part of the disciplinary invite. This is contrary to the disciplinary procedure of the respondent at page 33, specifically section 3.1. Miss Boxer did not bring up any new evidence or reasoning to support her version of events, and we've heard today categorically that she agrees that she did walk out of the meeting before it was properly concluded. The claimant's dismissal was confirmed to her by letter dated and emailed on the same day, the 13th of September. A right of appeal was not included in the letter, and Miss Boxer did not make any attempt, we've heard today, to make contact with the respondent following receipt of that letter. It's noted that Miss Fighter, the other participant in the fight, was not suspended and has continued to work with the respondent. The respondent subjected her to a disciplinary process, and the outcome of that was a final written warning, which differs from the outcome to the claimant. which draws me and brings me to the conclusions that I will find today. Firstly, I'm satisfied that the claimant did not resign and was dismissed by the respondent. I accept that in the heat of the moment, Miss Boxer did say words which may have been interpreted as a resignation and left without company belongings, but this was certainly in the heat of the moment, and no confirmation was sought from the claimant, which should have been expected and required by the respondent under the circumstances. The following documents, whilst accepting of a resignation, also set out the grounds on which Miss Boxer would have been dismissed in any case, and we've been very clear on what we've heard today, that she was dismissed for conduct. Therefore, I'm satisfied that the reason the claimant was dismissed was the act of being involved in a physical fight with her colleague. I deem this to be a fair reason under Section 98 of the Employment Rights Act, as the claimant's actions breached the disciplinary procedure, which state that any acts of physical violence or bullying will be considered as examples of gross misconduct at Section 6.2 of the respondent's disciplinary procedure. As I said at the start, it's not for me to substitute my view for that of the employer under these circumstances. Dismissal is only unfair if I am satisfied that no reasonable employer would have dismissed the claimant. The actions of Miss Boxer in violently punching her colleague were highly inappropriate. Miss Boxer did not apologise or appear remorseful in any way for her actions, whether through the process itself or during the hearing today. I'm therefore satisfied that her actions were in breach of the disciplinary policy and constituted gross misconduct. However, the common sense proposition is that where two employees who have committed the same offence are treated differently by the employer, the tribunal should ask whether the distinction made by the employer was within the band of reasonable responses open to them, or so irrational that no reasonable employer could have made it. It is possible in this case to make a rational distinction between the two. Miss Boxer appears to have escalated a verbal comment to a physical and violent altercation, and her colleague suffered a more serious injury that required medical treatment. Furthermore, the claimant's aggression continued after the altercation itself to not only direct itself to fellow colleagues who intervened, but we've also seen some aggression during today's proceedings. Further factors such as the two individuals' length of service and the claimant's previous conduct also played a part and a factor in the difference of the treatment. Therefore, I am satisfied that the virtual test is also satisfied in relation to the claimant's conduct, and the dismissal on this basis does fall within the band of reasonable responses. The next question is whether a fair procedure has been followed, and I certainly asked specific questions on that point during the hearing today. In light of that, I find that a fair procedure was not followed by the respondent, and in fact there are several incidents where the respondent fails to uphold a fair procedure. Although the investigation process itself seems to have started almost immediately, it is not best practice to leave an employer suspended with absolutely no contact for 2 months. I cannot comment on the claimant's availability to answer the phone over the summer, but the respondent had both email addresses and postal address of the claimant and did in fact contact the claimant via email, as we've seen in the bundle, to invite her to an investigation meeting. Furthermore, the appointment of Mr. Bias to the investigation was unfortunate, and more should have been done to ensure an impartial investigator. The size of the respondent suggests that there should have been other employees available to conduct that investigation, and it would not have been unreasonable to find an alternative once the issues regarding Mr. Bias had come to light. The appointment of Mr. Bias certainly did not help calm the animosity, and the decision to dismiss ultimately laid, however, with the disciplinary chair that we heard from today, and not Mr. Bias. Further fuel was added to the fire when an email was sent to the claimant asking for her to return company property, that email being found at page 30 of the bundle itself. Whilst I accept there may have been a legitimate reason to ask for that security pass to be returned, this was not explained nor conveyed to an appropriate level within the email to the claimant, and the email mistakenly requested for all items to be returned. Finally, the error in presuming the claimant had resigned meant that the claimant was not informed of the right of appeal that she should have been informed thereof. Therefore, I find that the dismissal of the claimant was unfair on a procedural basis. In finding that the process of the dismissal was unfair, I also must consider, as the next question, whether Miss Boxer did in fact contribute to her own dismissal. As I've already stated, Miss Boxer's actions did amount to gross misconduct, and I've considered that in any event the respondent could have legitimately dismissed her without much further delay in following a fair process. I have also carefully considered Miss Boxer's actions and her own contribution towards the dismissal when considering possible remedies. I therefore find that the Polkey argument and the contributory fault arguments are significant in this case. As such, I'm awarding Miss Boxer 2 days of pay, as I believe that this would have been the time needed to complete and carry out a fair process. However, I am reducing this award by 75% due to her contribution to the dismissal. That concludes the judgment of the Employment Tribunal today, and I thank both parties and the public for their attendance. Thank you.
Thank you, sir. I
All
don't know what I'm
right.
going to do again. There we go. Thank you, sir. I know there's lots of law in there and it's quite heavy because that's what they do, they read out heavy judgment. But did you understand the core things that came across there? That Mr. Taskett, as the judge was saying, that we had a fair reason, like when Oliver went out the room before, I think even the people who thought, like yourself, Lawrence, it was a fair dismissal, you still thought the procedures were a bit unfair, but I don't think you appreciated that actually then makes the dismissal unfair. So you can have a complete cast iron case. We've had cases of people being found stealing CCTV evidence, caught doing things, and our clients have, dismissed on the spot because they think there's such thing as instant dismissal, there isn't instant dismissal. And then when they phoned us up, they were completely appalled by the fact we're saying you're going to have to pay some money. Not a lot of money, but you will lose because of procedures. So that's what we're trying to get across today, is there are most employers, respondents win it when they go to the tribunal. And it's like the judge, Oliver was saying, the judge won't substitute their decision with yours. Oliver might have thought, actually, I wouldn't have probably dismissed. But it doesn't matter. The judge's job is to consider whether it's in this band. So it's quite a big band. And we only went wrong, the respondent, because of the procedures, not sending the statements before, not changing it after Mr. Bias was appointed. I get loads of clients phone me up saying, the employee's raised an issue about the chair or the investigator, and the client doesn't agree with that issue. And I go, well, even if you don't agree with it, if you've got somebody else who can do it, remove the issue. You don't have to accept anything. You can say straight away, we don't actually think there is any bias. We think that person is independent. However, we will change the investigator. We will change the chair, because you're just then removing an issue that you haven't got to deal with at court if it ends that way. I always say, if you can remove an issue, remove it, because it will make it a lot easier and you'll avoid these procedural arguments. Because I say 9 out of 10 people who phone us, they've actually got a decent reason to dismiss somebody, because that's why they're phoning us. But it's the process that lets them down. Go, Kevin.
So you said about the procedures and about the size of the organisation.
Yeah.
So would the still have found the same if it was a one-man band, or that wouldn't necessarily have the HR department, or
Well,
I mean, is that?
I think in this case, they would have still found it a procedural unfair because the policy, for example, says 7 statements. I mean, they didn't comply with their own policy. So that when you don't comply with your own policy, you're kind of like in dead water, really. But it would be taken into account in a bit, but I don't think, even if you're a one-man band, that decision would change, because I think procedures were so not correct. If, for example, you're a one-man band and the Mr. Bias, if it was just the Mr. Bias argument.
And you don't have a policy, presumably.
Yeah, so if we were dealing with this case and everything else was fine, but the only issue was Mr. Bias being biased, and you were a small entity that didn't have anybody else that you could change, I think the dismissal would be there, because ultimately it's Henry Humbug. But that's if the other things were rectified, the documents were sent, Mr. Humbug maybe adjourned and gave the person longer to read the statements, or there was obviously the statements were sent before. So yes, the reason why there was an expectation to change Mr. Bias here was because of the size of the organisation. I'll always say to clients, have you got somebody else who could do this? Yes, get them to do it. So that's what we're trying to say. And I think clients often get frustrated because I think we're saying you can't dismiss somebody. We're not saying that. We're saying it's often about the tick boxes, and the tick boxes can make something that could have been a fair dismissal turn into something that, and I know this wouldn't have cost a lot of money because there was a reduction because of contribution, and so therefore the award that the individual was given wasn't a lot, but you've still got an unfair dismissal claim that you've lost, which is, if somebody searches it, it's against your company. And also, us lawyers aren't cheap. We're obviously very reasonable and very good, but going to court all the way costs quite a lot of money, and that could have been avoided. So you've already incurred money, and then you're still having to pay out, and you've got an unfair dismissal claim against you, and once the press go, it doesn't look very good. So it's all about the process. If obviously, we will tell you if the reason's not sufficient, but generally people have phoned us up. We might have situations where we're trying to facilitate people going because there's other reasons, and that might result in some kind of settlement discussions. But generally, when people phone me up about a conduct issue, there is a decent case, then it's just about ticking the procedures. And clients think we're just trying to overcomplicate things. We're not. We're trying to avoid these procedural arguments. So did you want to add anything, Oliver, to that?
No, as you saw, the judgment at the end in terms of the compensation found that it would have only taken a couple more days to have rectified issues. So, for example, when they got to the disciplinary hearing as well, it was raised, look, I didn't have these investigation statements before. You could have postponed that hearing, put it back only a couple of days to consider that. Then you again rectify some significant procedural issues. So, whilst the award was small, so 2 days to rectify that could have easily been done anyway, so you avoid the finding of unfair dismissal. But then with conduct, there's going to be a contributory element. So that deduction and reduction of 75% of those 2 days is significant. So values of claims, when you're looking at it from the very outset, can be relatively low. And it's most tribunal claims we don't get to a final hearing. That's why a lot of people attend these events. So it's making a commercial decision with advice at an early stage to decide what's best to do as well.
Yeah. So we often get people phone us, and unfortunately they haven't taken our advice before. That sometimes happens. People dismiss people, or people don't follow process, and they're phoning us up, and they've got this tribunal claim which seems pretty scary. Like Oliver said, if generally you haven't sacked somebody who's pregnant on the spot, which might end up being quite an expensive claim, if you look like you follow some kind of process and they have got a genuine reason to dismiss somebody, it's often a lot better. It's not going to be a massive claim, but you just avoid all that hassle of management time. The amount of management time, ignore the legal costs involved in a tribunal claim, can be massive. You're already busy, you don't want to be having to do witness statements, prepare, then have to go to court. So if it means that you could just, I know it's annoying when we say things like you've got to postpone the hearing, I know you hate it, and the first thing we go is, you're going to hate what we say, but you're going to have to postpone it. But that's because that postponement of those 1-2 days could mean that, it's procedurally fair rather than it being unfair, just because it basically is technical error. That's what it is, a technical error. So, and that's what we see time and time again, that people normally vote. The amount of time we still get people sacking people on the spot, don't we? Because they say, I thought you could sack people on the spot. It's called that instant dismissal. It's not instant dismissal. What it is potential gross misconduct, which means they're dismissed without notice, but that is still after a process. And that doesn't mean a 3-month process. If you do start to finish and it's an investigation, it can be done in a couple of weeks. It doesn't have to be an onerous task. You know, this process, if there hadn't been those delays, could have been done within 2 weeks because they got the statement straight away. There could have been an investigation hearing, opportunities for statements before. That could have been done within 2 weeks. So we're not, it only went on for longer and cost more because the individual was suspended so long without any contact. Again, we see that all the time. People being suspended 6 months, 7 months. First of all, you're paying them full pay. So that's a heck of a lot of money. And then it's creating procedural issues, which you've then got to rectify later on, because why is somebody being left without any support or contact? Because that's not good. You know, they're innocent until proven guilty. They might not even have done anything. They're suspended on full pay. Often they can't then return. Relationships often broken down. So there's lots of little easy things you can do. We've tried to highlight those things, and every case will be different. Every case you'll get somebody wanting this document or wanting this statement, and you've just got to exercise reasonableness. But I think if you ignore the law sometimes and just sit there and go, could I change this? Could I get that statement? Could I change that investigator? Could I give them a delay? And if you can do it and it's not causing you too much hassle, do it. Because you will just look more reasonable in front of a judge like Oliver if you end up there. Okay, does that make sense? Thank you. Well, we'll try and do these mock tribunals quite a lot. We did this one, like I said, recently, so it's the same one we used last time. But we'll try and think of another more, you know, a different topic, maybe a discrimination one or something that we can do next time, because we know that these are quite useful. Because of us just citing the law at you, you know, you need to know how that works in practice, don't you? Thank you. Well, we'll put in your packs, and we won't let you leave unless you do this, a feedback form, which is really just obviously, it's really to help us know what you want to hear, what issues you have, what seminars or events you want, because we do these, but there's no point in doing all these events that we do about every 3 months if we're not catering for the right issues. And also, if you put any details on there and how amazing you were, that would be much appreciated. And then Taryn is going to stand at the back and not going to let you out until you give her it. Anyway, thank you. We'll be hanging around for a bit if anybody's got any questions. You've got all our contact details in the packs. So if you think of anything later, if any of your colleagues, like I said, want to attend the event in Lincoln, which is it next Wednesday, Oliver?
Next Wednesday, the 12th, yes. Yeah.
It's the same one, so obviously not applicable for you, but you might have colleagues who, or friends in other businesses that you think it might be useful for.